Testing 1, 2, 3, 4. Testing 1, 2, 3, 4.
The matter before the court is Piscataquis County 24-169, Moosehead Mountain Resort et al. Versus Carmen Rebozo Foundation. Counsel are present. I'm going to ask that you identify yourselves by saying your names for the record, starting with the appellant.
John Flagg on behalf of the appellant.
Teresa Cloutier on behalf of the foundation.
Thank you. We are being streamed. We are having some technical difficulties, so we don't have as much control, I guess, over the sound as we ordinarily do, but we are being streamed both by video and audio on the web. And Mr. Flagg, if you're ready to proceed, we'd be happy to hear your argument.
Good morning. The appellant makes his living by buying and selling real estate.
Counsel, I see that the green light is on. Can we revisit this a little bit procedurally?
Yes.
My understanding is that the court dismissed the case, and then you filed a motion to reconsider or set aside that dismissal, correct?
Correct.
And at some point, the defendant filed a motion to enforce. Is that right?
That was before we filed the motion for reconsideration.
They filed a motion to enforce before you filed a motion for reconsideration? I don't believe so, but once the court has dismissed the case and denied your motion to reconsideration, is there anything in front of the court to enforce?
Well, one of the things that we were trying to get is an accurate payoff because we had a buyer for the mountain.
Well, I understand that's why you wanted to set aside the dismissal. But I'm trying to figure out what was actually in front of the court and what the court had jurisdiction. If the case had been dismissed,
right, well,
and the court denied your motion to reconsider, how did the court have jurisdiction to do anything at that point?
that's not what's on appeal now, I believe. The question is the dismissal is on appeal. So
Okay.
I might agree with you that there was nothing for the court to enforce at that point.
What's the standard for, well, do you agree that given what was in front of the court was justified in issuing the dismissal in the first place?
Oh, no.
No. Why not?
What happened is we had a mediation, we had a settlement agreement.
I know what happened. I don't understand why the court wasn't justified in issuing the dismissal. Having given an order that says the case will be dismissed if you didn't file the settlement documents, giving in 30 days, giving far more than 30 days, ultimately the court dismissed it. Why is that not correct? And we'll then get to the reconsideration.
Because this so-called settlement agreement, which we agree we entered into, but it took the appellee a year to come up with a settlement agreement. So if there was already a settlement agreement, why were we doing a settlement agreement?
Okay,
And it
counsel, I don't understand how that's responsive. Why was the court not, court issued an order once the parties indicated to the court that the case had been settled, right? Following the settlement conference,
Correct.
The first settlement conference with, I think it was Justice Cole, correct?
Correct.
All right. Told the court it had been settled. Court issued what is in fact a standard order.
Yes.
Saying, okay, parties have represented that the matter is settled. The case is going to be dismissed unless, file docket entries within 30 days or the case will be dismissed, right?
Right.
Did anybody file any docket entries within 30 days?
I ended up filing my own docket entries because I couldn't get
Was that before or after the court had filed the dismissal?
That was, I believe, before.
Okay.
So,
And your docket entry that you filed said nothing needed to happen, right?
correct. And in the meantime, the
I understand.
foundation.
No, I understand.
But that's critical.
There's a lot going on behind the scenes. My question is, what does the court know? At that point, when the court dismissed the case, what does the court know?
So, at the time that the court dismissed the case, the court did not have the conversation back and forth between counsel about trying to come up with an agreement, because the settlement agreement said we're going to come up with a settlement agreement. It took us, it didn't take me, it took a year to get a settlement agreement. So by the time we came down to the settlement agreement, it changed the terms of the entire loan. It changed the terms that went back to 2013. That mortgage has over 30 paragraphs. You don't know when you're in a settlement.
Was there a motion to enlarge the time to file docket entries filed with the court? And let me be clear, part of the reason I don't know the answer to that is because the docket entries were not included in the appendix, contrary to the appellate rules.
So what's the question?
Was there a motion to enlarge the time to give you more time to file a judgment, a settlement, or whatever it is you wanted to file with the court?
No,
Before
because
the dismissal I'm talking about.
I couldn't get any agreement on that. We had a settlement, we were ready to sign, file it with the court. We even had emails back and forth with the clerk trying to get counsel for the foundation to file it, and they wouldn't do it. So we filed our own. And in the meantime, the court dismissed the case. So we filed a motion for reconsideration and explained
And what's the standard for reviewing the motion for reconsideration?
whether the court made an error of law or fact.
Okay?
And what they didn't know was that going on behind the scenes was this change of the loan terms. So the court said,
Whose job is it to tell the court?
what's that?
Whose job is it to tell the court that there's something going on and that we shouldn't dismiss?
Well, that's what we did in the motion for reconsideration. That was the whole point of filing that.
Okay. So the court dismissed it was in June of 2022 that the court was notified there was a settlement and then issued an order to file docket entries, right? And it wasn't until February, 8 months later, that the court finally dismissed it, and nobody had filed anything in between.
Yeah, that's right. Not for a lack of effort. I made all kinds of effort as laid out.
Something?
Pardon me?
You made all kinds of effort to file something in the court?
To get the settlement agreement and the stipulation of dismissal filed with the court, and I couldn't do it. It took me a year, 10 months. So the Superior Court said, well, if you've got an issue now that's come up after the settlement agreement about this, the way the payoffs worked. So we would sell a piece of property, did this 5 times since 2013. Sell a piece of property, half of the money would go to the mortgage pay down, not a profit participation agreement, none of that craziness. It went to pay the mortgage. The other half, my client lived on and paid the interest on the loan. And that happened.
None of that is in the document that was signed from the settlement agreement from the conference, correct?
That was not in the agreement. Either was the 30 other paragraphs in the mortgage in the agreement. We had no idea that they were going to try to change, during the drafting of a settlement agreement, the terms of the loan since 2013. So, I mean, you're sitting there in a settlement conference, you're trying to imagine everything that, you need to settle. That issue was not an issue in the original lawsuit. The Superior Court's just wrong on that. We never brought up the issue of the way we paid off the loan. And it's documented from 2013. Not only is it in writing in 2013, his own lawyer in the foundation's own lawyer in 2018 said, yeah, that's the deal. And then we did it 5 times. So the performance of the parties was clearly to pay down the loan and live on the rest. So we get to a settlement agreement. This comes out of nowhere, comes out of left field. We don't even know how this came up. So we said, no, hey, we can't do that. This is how we live. This is how we survive. This is how we make a living. And they simply changed the terms, and so we couldn't get a settlement agreement done. And here we are. And so the Superior Court said, well, when that issue gets raised, bring it up then, file another lawsuit. Why? We're already here. The way that
Well,
we
it
get...
didn't work because the case had been dismissed. That's the problem.
Yeah, and so the court should have reconsidered the dismissal and not make us go through a whole nother lawsuit, because the way we do this is we get a buyer, and this is what happened in real life back in 2020. We had a buyer to buy the ski mountain, and because it took us a year to get a payoff, and that wasn't even an accurate payoff, the payoff changed 3 times. A total of the change alone was $2.5 million. Every time we asked for a payoff, it went up. So the way that this guy operates is he gets, and that's the appellant, he gets a buyer. He then goes and asks for a partial release of the mortgage. He did that in 2020, and because we couldn't get a payoff, the buyer eventually walked.
Well,
They're investors.
doesn't that go to the reason why the court felt that you were aware of the issue with respect to how the partial payments were going to be treated back in 2020?
We didn't have any idea they were going to try to change the terms. That is the way it worked.
But that's in your complaint, I believe, at paragraph 29, talking about the issue that had cropped up in 2020.
My brief or the appendix?
Well, I was talking about the complaint, so the appendix page,
Oh, yeah.
A20, A84.
Yeah, this was the discussion going back and forth, but that wasn't the point of the lawsuit. The point of the lawsuit was to get a payoff. It wasn't to get a partial release.
Well, that had been part of the pattern of practice as to how these parcels were sold.
Oh, absolutely.
And so that was the point that the court took in issuing the decision that you ultimately got after you filed your motion to enforce and to reconsider.
Right, but the point of this lawsuit was to get an accurate payoff. It wasn't the issue of how the money was treated after the closing was not an issue, because we never went to a closing. We couldn't even get there. We couldn't get the accurate payoff. So now this guy is going to go get a buyer, and then they're going to say, we're not going to give a partial release, as they're obligated to do in writing since 2013 and by practice of the parties, and he's not going to get an agreement. So now he's going to have to sue. Now that's going to take a year or two. He's going to lose his buyer. Then he's going to get foreclosed on, because the lender is going to say, hey, you haven't paid the mortgage down. No kidding. We can't get a payoff.
But you're going back and forth over this period from the time that you have the settlement, or the judicial settlement conference, I should say, with Justice Cole, and that's back in June of 2022.
Yes.
You get an order from the court in November of 2022 that says you need to file docket entries with respect to the settlement that you reached. So from June until November, or strike that, from June until November, you haven't reduced the agreement to writing and presented it to the court. You've had something that's gone back and forth between the parties, correct?
Oh, yeah.
But you haven't introduced that to the court.
Right.
You get an order from the court to file docket entries, and you then are coming up on December of 2023, recognizing you've got a deadline with respect to filing docket entries, and there's more correspondence between the parties. But nothing's been filed with the court. Is that correct?
Correct.
And then ultimately, after the deadline for filing the docket entries has passed and the court dismisses in February of 2023, that's when you file the motions for reconsideration and
Right.
to enforce.
That's exactly right.
And the court denies your motion for reconsideration.
Right.
Case is over, correct?
That's why we're here. I mean, it doesn't make sense to make us come back for a whole new lawsuit.
But if the court's denied, or the court's denied your motion for reconsideration, and therefore the docket entries stand with respect to the order that's issued by the court, It's an advisory opinion, isn't it? The case is over.
The case is over. It should be reversed.
Thank you, counsel.
Thank you.
Attorney Cloutier, I see that the green light is also on for you.
Yes.
And I'm going to really go to the same thing. Once the case is dismissed on February 8th, I think it was February 8th of 23, and that's shortly thereafter followed with a motion for reconsideration filed by the plaintiff. My understanding is that you then opposed that motion to reconsider the dismissal and also asked the court to enforce the agreement. Once the court doesn't reconsider, I know there was a lot that went on before we got to that point, but once the court denies the motion to reconsider and the dismissal stands, there's nothing to enforce at that point. Is there? I mean, the only judgment from the court is dismissed.
Correct. It's my understanding, based on the case law, that when, particularly, especially when a settlement's reached in the context of a judicial settlement conference, the court retains jurisdiction to enforce the settlement agreement that's reached.
Can you give me a site when let me be clear. As opposed to a case like in a lot of our settlement agreement cases, for example, are family cases, where the settlement is supposed to result in a judgment of a divorce or whatever it was that they agreed to settle. And it does not simply result in a side agreement and a dismissal. Can you give me a case where the agreement, the settlement agreement, was not part of a judgment, was never part of the judgment when the court was able to, we said you can enforce it once the case is dismissed?
Unfortunately, I can't, because the plaintiff, throughout the course of this process, never challenged that the court had jurisdiction to enforce or not enforce the settlement agreement, and didn't brief that. So, I didn't compile those cases, so I apologize. I didn't realize it was that. It's a good question, but I didn't realize that.
Well, I think once the case is dismissed, there's nothing there, which is different from a case where the judgment itself may, incorporate terms of a settlement or the cases where it was litigated where a settlement was really reached prior to entry of the judgment.
Yes, I wish I could. That was my understanding, that the court did retain jurisdiction for that purpose. But
Okay.
Well, in this context, there wasn't an agreement. You had the settlement conference, judicial settlement conference, but at that point in time, there was nothing put on the record as to what the parties' agreement was, from at least what I can see in the record. Am I correct?
correct.
And in fact, although there was something reduced to writing, it appears on the same day as the judicial settlement conference, that was never reviewed and approved by the court, was it?
It was not. We filed the motion to enforce that settlement agreement based on the writing and the evidence around that was presented in the various motions around.
Isn't that an action for breach of contract or to enforce a contract, which is a separate action?
It could be, and I really wish that I had looked at this earlier, but it was my understanding that was one option, is to file a separate complaint on breach of contract.
The way I've seen the situation play out, when the court is notified that a civil action has settled and issued what we used to call a 30-day dismissal order, which is what the court did in this case, November 18th, is that if the settlement went awry, there would be a motion to restore the case to the active docket, and then maybe a cross motion to enforce the settlement before the court acted on the dismissal. Do you know why almost 3 months went by from the original December, I'll say 2 months went by, from the December deadline to when the court dismissed the case in February after hearing nothing?
I'm not certain why there was that delay. I mean, there had been some discussion with the clerk's office. We had actually offered to extend the deadline if Opposing counsel felt that other documents were needed, but the record, as you can see from the appendix, shows that they were
To get to
insistent.
the Chief's question, my impression is that all the court could do in this context to enforce the settlement would be to dismiss the case with prejudice, which it had already done, rather than to, I don't know what it would have looked like, enjoining the Moosehead to follow through on the terms, or, it's hard to know what that would have looked like. So it seems to me that the court had already done the enforcement that it needed to.
So, I would ask, because this wasn't argued by the opposing party below, and because the court, in fact, made the decision, I know that they didn't expressly do so, and maybe this is, it's a bit of a waiver argument with respect to the appellant, but I think we could imply that the court restored the case to the docket and then decided to enforce the settlement agreement.
But if the court restored the case to the docket, wouldn't that mean that the court granted the plaintiff's motion? And the court said it denied it.
Well, right. Well, for the limited purpose of considering the settlement, and then in the context of enforcing the settlement, it then dismissed the underlying claims in keeping with the agreement that the suit would be dismissed.
But you would agree if there's no case, then it becomes an issue of jurisdiction. And isn't jurisdiction to be able to do anything, that kind of jurisdiction, isn't that able to be noticed by us at any time?
I can't deny that it's a subject matter jurisdiction issue, but I would just be, given the years that this case has been going on.
Understood.
That if there's a way for the court, based on the fact that this issue was never raised by the plaintiff below, and I understand that you can raise it yourself, and the fact that the court, in fact, did consider the case, consider the settlement, and take action, if there's some way to imply that the court did everything that they needed to do to support its decision, I would ask the court to do that, because I don't believe that there's a motion for further findings or whatnot filed by the appellant. And so
What's the standard of review for the court's denial of the motion to reconsider? I mean, isn't it just
I think that's
abuse of discretion?
Yeah, it's abuse of discretion.
Do you think there was an abuse of discretion in failing to reconsider the dismissal? And set it aside?
I'm just thinking, the way that this occurred, I'm asking the court to imply that they did at least restore the case to the docket long enough to enforce the settlement agreement.
Counsel, why did it take so long to file something with the court? I mean, Attorney Flagg is saying the defendant, you had an agreement. I think at some point here in this record, it seems like you both agreed you had an agreement, and all that had to be done was it had to be filed with the court pursuant to the court's order. Why didn't that happen?
It's a good question. I mean, there was discussions about drafting settlement agreements, and just due to the press of business, the offer was made to the other side. Both parties have an obligation to draft settlement documents, and so it didn't get drafted. And the insistence by the other side is that we have an enforceable agreement. You have a copy in your file. It's all over the record.
Well, it seems sort of odd. It seemed like the position was switched, where the agreement was already done, or then suddenly it wasn't.
The message I was getting from opposing counsel was, I don't understand why we need additional documents. We have a signed term sheet, and so we accepted that at the end of December. We said, okay, the court can dismiss the case then, and we have an enforceable settlement.
Dismiss the case.
We have an enforceable settlement. But then, in the context of the motion to reconsider, and he also they joined that with a request to go back to. I believe the motion was a request to reconsider the dismissal and also to go back to another judicial settlement conference. And the court did that. The court actually sent us to a second judicial settlement conference.
We know. That's why Justice Meade isn't here.
So, right. And so, the court did revive, whether they expressly did so or not, the court did revive the case to some degree to consider the issues that were before it. So, I mean,
There don't appear to be additional questions.
Well,
Okay.
actually, I have a
I'm sorry,
question.
go
So
ahead.
what are you asking the court to do?
well, we're asking the court to do what I just asked you to do, which is to somehow find that the court restored the case long enough to rule on the enforceability of the settlement, and then in conjunction with that, dismiss the case after making that ruling. Because we find that our position is that if the jurisdiction existed, there was more than enough evidence to support that settlement. And so we would ask you to enforce the settlement agreement as written. There's just no evidence to support the argument. And I'm just going to put it out there, all the comments about we can't get a payoff, there's this urgency around closing. Was a buyer that's been in place for, since 2016. That buyer has never been ready, willing, and able to close. The appellant filed motions in this court in the spring, asking us to provide another payoff because closing was imminent again, but closing didn't happen. That buyer just was not able to close, and so not providing a payoff from the foundation is not something that's interfered with their ability to sell this property. Their buyer just can't buy it. So,
Counsel, would you like an opportunity to provide additional authority to this case that the court below retains jurisdiction over a settlement agreement that was not incorporated into a judgment nor filed before the case was dismissed?
I would love that.
Okay. How much time? And I'll give Mr. Flagg the same opportunity, but what's the rule? You know the rule.
Well, are you going to do it as like the 150 word?
Yeah.
Or you can.
You say it. She's very clear on this.
Well, is she? There's a rule that talks about citation of supplemental authority. And this doesn't exactly fit, but let's use the terms of that rule, which gives you, I think, 300 words or 150 words. You put it in a letter, and there's a deadline for that. So just follow that rule, and I don't have the rule book in front of me.
None of us do, which is why.
And we could issue an order.
We could issue an order, or we can just ask you to do that, and we will give you the citation for the rule, but within 2 weeks.
That's fine.
Mr. Flagg, is that okay with you as well?
That's fine.
Okay.
And I'm sorry, and we're going to do, I'll follow the rule, I guess, but is it a simultaneous briefing situation?
I think
It's a supplemental authority.
Yes.
And the sole issue is the authority of the court to enforce an agreement that, A, is not incorporated into the judgment after dismissal, when until that point, the agreements had not been filed with the court.
Understood, thank you.
And it's very short. It's a letter.
Yes.
It's no table.
Basically, cite cases for us is what we're looking for, if you think there are some.
I would love to, thank you very much. I think you...
And you actually do still have a couple of minutes, so I don't mean to cut you off.
No, I just was rebutting that concept that we are the evil empire who prevented them from closing. They've never had a buyer.
Okay, well, I'm told by the clerk that it's not simultaneous. What's the rule?
Rule 7, capital A, subdivision I.
Why don't I do this? I'll issue an order.
Because it's not simultaneous. It's
Okay,
one
I'll
files
issue
the
an
other.
order.
Okay.
But the question is the court's jurisdiction to do, essentially, to do what it did here, which is enforce an agreement that was not part of a judgment after the case has been dismissed.
Thank you, I understand.
Thank you. And Mr. Flagg, did you have?
Nothing.
Okay. All right, I'll issue an order and then give you some time to do that. Thank you.
Thank you.
With that, then, this matter will be in recess. I won't say that we're going to issue a decision in due course, but we'll wait for the authority on that first. All right.
All right.
And you may be seated. The matter before the court is Penobscot 24224, Stuart Carney et al. Versus Hancock County et al. And counsel are present, and those attorneys who are going to be arguing, if you would identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Peter Marchese, and I represent all of the county defendants other than Mr. Wall's client.
And I'm John Wall, and I represent Respondent Gilbert Dumont in this case.
Good morning, Your Honors. I'm Scott Lynch. I represent the appellees, Stuart Carney et al.
Thank you. We are being streamed live on the web by both audio and video. And if counsel are ready to proceed, Mr. Marchese, I understand you will lead off. We'd be happy to hear your arguments.
Thank you, Madam Chief Justice, Associate Justices. Again, Pete Marchese on behalf of the county respondents other than Ms. Dumond. My time is short. I'll jump right to it. This case presents the important question: what is the scope and the reach of the Maine Health Security Act with respect to who claims can be brought against? The answer significantly impacts not only jails and jail employees, but also other institutions and their employees, such as schools, colleges, universities, and group homes. If a county jail and its correctional professionals can be respondents in a Health Security Act claim merely because the jail is required to contract with medical professionals to provide care to inmates, what about schools and school teachers? Are we to say that merely because an educational institution retains a medical professional, perhaps a nurse, to minister to its students, that it and its teachers, who may be called upon to render aid to an injured student, can also be respondents in a claim under the Health Security Act? These cases are becoming more frequent, prevalent indeed, and in fact, as we speak, there's another one on this court's docket. This court has recognized time and again that the clear legislative intent behind the Health Security Act was to protect access to medical malpractice insurance to those in the healthcare industry. Yet counties and county employees have no need for such insurance. They're already immune from tort liability. It's questionable whether non-healthcare entities would even qualify to be able to procure medical malpractice insurance. And even if they could and did procure such insurance, it would be at their peril, as, at least to the counties, they would then waive the statutory immunity which they already enjoy under the Tort Claims Act. I urge the court to take the opportunity of this case to insist that those bringing claims under the Health Security Act and courts reviewing those claims hew to the statutory definitions of healthcare providers and healthcare practitioners as set forth in the Act, and to stem the veritable explosion of cases that are being filed under the Health Security Act against institutions and individuals who are not employed or involved in the healthcare field. As respects this case in particular, there are two groups of entities that can, I won't say be liable, but who can be respondents under the Health Security Act. They're the providers, which are institutions, hospitals, clinics, nursing homes, and as the statute says, other facilities, and we may get into that on the one hand, and individuals on the other, doctors, podiatrists, chiropractors, the list goes on and on. And we have both groups in this case. We have institutions and we have individuals. The simplest way to resolve the question of whether the individuals should remain in the case is to look at the second amended notice of claim, which is the operative notice of claim.
Can we actually, before we dive into the Health Security Act, just want to ask you a question that may be more appropriately addressed to your colleague there. But as a threshold issue, the Maine Tort Claims Act immunity, were employee Dumont's duties discretionary, as alleged in the complaint here?
Well, I'll answer that question, Justice Meade, on behalf of my clients.
Right, I'm asking,
and I think that will
asking
apply
again.
equally to Ms. Dumond. And the answer is, as a matter of law, under this court's pronouncements in both Erskine and Roberts, the answer is no.
You're
Yes.
suggesting that as a matter of law, as a result of our pronouncements, whatever jails, corrections officers do, if it's related to inmates, they're immune?
What Roberts and Erskine say, yes, Your Honor, essentially.
They essentially can never be. What if, if it's intentional and deliberate indifference, are you saying that they cannot be held liable?
Well, they cannot be held liable under tort law. Now, there certainly can be held liable for deliberate indifference under Section 1983.
Well, let me read a ruling from our brethren in the federal district court, where they say that where there's a deliberate, an Eighth Amendment, Section 1983, with a pendant MTCA, that the defendant is, quote, not entitled to summary judgment on a Maine Tort Claims Act by dint of an absolute immunity defense that he was acting within the scope of the discretion. So they're saying that when it's deliberately indifferent, it could fall outside the discretionary function, and they are relying on Richards versus Town of Elliott, which had to do with excessive force, and they extrapolate that to deliberate indifference. So if you and there is a federal case that's pending, and shouldn't we leave the Tort Claim Act with them with a deliberate indifference, because the issues relating to immunity are entwined with the deliberate indifference federal claims?
So I'd answer that question at least two ways, Justice Conner. One would be that that is a federal court interpreting this court's precedent, and it is not binding on this court. This court's precedent is clear in both Erskine and Roberts that the care and custody of inmates is a matter of discretion.
We did not address in those cases deliberate indifference.
But deliberate indifference is an entirely different species of liability. That's a constitutional
I understand
standard.
it may be a species of liability under 1983, but we did not address in those cases as to whether deliberate indifference would take them out of the immunity for discretionary function.
So you're correct. You didn't discuss that.
In Richards, we did say that when an officer uses excessive force, they have exceeded the discretion, so that the discretionary exception did not apply.
So those cases really are distinguishable in any event, because there's no allegation here to avoid the immunity that there was deliberate indifference.
Can I just take you
The
one
allegations
step
here
further?
are negligence.
Can I take you, on the short time you have remaining here?
Yes.
Plaintiffs are saying here basically that upon report of A, B, and C, that the jail employee must do D, E, F. There's no discretion involved. In other words, if the red light goes on, they have to push the green button. No discretion. Your response?
And I understand that's what they're saying, but
Yes.
the law says otherwise. The law says, and we've cited some case law in the briefs, both appellants have, to the effect that where the court has said that it is a matter of discretion as a matter of law, the fact that there's a particular obligation to do a particular thing doesn't remove the discretion. And I'd simply remind the court that under 8111(1C) of Title 14, the discretionary function immunity applies even where the discretion is exceeded or abused.
Thank you, counsel.
Thank you, Your Honors.
Attorney Wall?
Yes, thank you, Your Honor, and may it please the court. I don't have any reserved time, so I'm happy to answer any questions
Well,
out of the
do
gate.
you
You know
agree?
what the question is.
Do you think that anybody associated with prisons are absolutely immune for whatever they do to an inmate because it relates to management and supervision?
I believe that what this court has held in Erskine and Roberts is that the supervision of inmates is a core discretionary function. And therefore, in the context of this case,
So you can torture them?
As a matter of tort, I think what you're...
There's
what-
no,
what
there's,
this-
they're immune from a tort claim under the state law for torturing inmates.
I think that would fall outside of basically your scope of your role as a corrections officer if you were to torture somebody. So you're outside of the Maine Tort Claims Act altogether.
Okay, so
Along the-
torturing would be outside. How about deliberate indifference?
Well, I've never seen that applied in the context of a Maine Tort Claims Act case where you're talking about the concept of deliberate indifference, which is, of course,
Well,
it's a term
is
of
in
art.
the federal court where they are pendant to the Section 1983s.
It is a term of art under federal law. I acknowledge that, Your Honor, but I don't think I've ever seen it applied in a or utilized as the theory of liability for the purposes of Maine Tort Claims Act issue. Maine Tort Claims Act, based upon the law that I've seen, is evaluated based upon the facts of the case and the prevailing law. In this case, it would be Erskine and Roberts in dealing with the supervision of inmates.
Does your client's role as part of the medical process going on, medical symptoms are reported, it comes to her, she passes it on to the person who does the next thing. So she's in that chain, I'll call it chain of custody of information that directly relates to medical care. Is she a medical care provider?
No, Your Honor.
Why not?
Because the role that she provides, even under that factual scenario, is simply one of supervision of inmates.
Well,
She
isn't it
is not-
facilitation of, I mean, we understand she's not a licensed practitioner. I get that. But isn't she facilitating, and doesn't the jail as a whole have the obligation to facilitate the provision of medical services, whether they do it themselves or whether they subcontract it to somebody else?
And that may be an issue with regard to the county that the court can address. From the perspective of my client, to the extent she, as alleged in this case, obtained information which suggested required follow-up, there was an unusual situation that policy requires a report, her obligation is to relay that information along to people who are medical providers.
Aren't there fact questions in this case as to the discretionary function for your client?
No, Your
And
Honor.
if there are fact questions, shouldn't we be dismissing an interlocutory appeal? And that is the elephant in the room. I mean, all of this is interlocutory.
Well, that's true, Your Honor, but there are no factual issues that bear upon the the discretionary immunity issue, because, as I've indicated, as this court has indicated in Erskine and Roberts, the supervision of inmates is a discretionary function, is a core discretionary function.
Is there an inconsistency in what you just said? You just said if a report is made, her role is just to pass it along, just that she's not a medical care provider. But you're also saying it's a discretionary role she's doing. Are those two concepts?
Exactly, Your Honor, and it's up to her to decide whether or not it's the kind of information that needs to be passed along. First of all, it's entirely within her supervision of the inmates, and therefore it's discretionary in and of itself.
But didn't Lieutenant Shepard testify that she was mandated to report suicidal behavior when it's reported?
And the issue was the information that was provided to her such that it was indicative of that kind of issue, such that she, under the policy,
Well,
was
either
required to pass
it's
along.
undisputed for purposes of the motion, in which case we can rule on it, or if it's disputed, which seems to be what you are saying, then we should not be dealing with that on an interlocutory appeal.
And which part is not disputed, Your Honor?
What her obligation was, and if you're disputing what information she actually got and whether that was indicative.
No, Your Honor, I think the record is clear in terms of what's alleged, the information she received, and I think it's clear from the record what they indicate the policies say in that regard. What is the link between those is she has to make a decision based upon the information that's in the record as to whether or not this requires her to turn around and make a report. That's
Well, she doesn't have to make a decision if it's reported to her that somebody is suicidal. There's no question about whether she has to report that, is there?
And as this court has already held in cases like Selby and Doucette and Norton, other policies that have required mandatory type of activities or prohibited certain types of activities.
But the captain gave testimony that Dumond failed to follow the mandatory policy. Doesn't that in itself raise issues of fact about whether it may be a discretionary function, but the discretion has to be exercised in order for it to fall within that exception.
No, Your Honor, because that's exactly what happened in Doucette when a dispatcher failed to log information that she was required to log under the policies that governed her activities. It's the same as Selby, where an officer engaged in a pursuit of somebody for a traffic violation when the policy said you're not allowed
Is
to.
logging information ministerial?
Well, it was part of the policy related to the activities, and this court held that it was discretionary
But in
on the part of the...
Doucette, we said that Thomas was called on to exercise judgment in evaluating incoming calls and determining how those calls should be handled. So obviously, Thomas had to make some decisions, but I think as Justice Horton just pointed out here, upon a report of A, B, and C, it requires that the recipient do D, E, and F. Not discretionary. There's no judgment involved in that.
And I would suggest, Your Honor, that any time you receive information as a corrections officer, you're required to evaluate it and decide what happens next. And that is, as this court has said, these controls on the behavior of the individual employees doesn't change the underlying discretionary nature of their activity. And as this court has held in Erskine and Roberts, that is, the core function is of supervision of inmates.
Thank you, counsel.
Thank you, Your Honor.
Attorney Lynch.
Good morning, Your Honor. Your Honors, the appellants abandoned a suicidal inmate, and she perished because a guard chose to go home at the end of her shift rather than follow a directly circumscribed, very specific stop sign. This happens, you do only this. Mr. Attorney Marchese mentioned that there's another case before you as an example of a floodgate that's about to open. Well, if there's a floodgate, it's about Hancock County, because that case that's just been docketed is another jail suicide, same players in many respects, another hanging in the jail because people didn't follow the mandatory policies. So you now have one that's coming up on a briefing schedule involving many of these same players. I want to go to the point that this is an interlocutory appeal, and they're trying to fall under the immunity exception to the interlocutory appeal. But as you have said, in Wilcox and Bean was in 2022, that if there's a question of fact about insurance coverage, you cannot avail yourself of that safe harbor as an exception to the final judgment rule. And here, they didn't put the insurance policy in play. They only provided the certificate of insurance, and the certificate insurance says there's coverage for incidental malpractice. Well, that term is not defined anywhere on the certificate of insurance, but incidental malpractice generally means it isn't the only thing that you do at your facility, but you are providing, as part of what you do, care. So I was asked at oral argument in the Superior Court, I believe, that, what about a police officer that provides Narcan? Are they acting as a health care provider? And my answer to that question is yes, in that limited, they're trained, they're certified to do that, they're providing a life-saving activity. If they do so incorrectly, we may not like where we are with jails and police officers providing that care, but it is health care. It is a health care service. Because you don't have the insurance policy, which says that provides all the definitions, the inclusions and exclusions, and just the certificate of insurance, they have not met their burden, as the Superior Court said, in showing that they fall within, that they're entitled to immunity. And you don't have that even now. It escapes me why they didn't put it in their reply memo. It makes me think that there must be insurance. And it would seem to me unreasonable to have coverage for employees and then not allow access to a wrong party when those taxpayer dollars were spent to acquire the insurance. And then, in order for them to prevail, they run squarely into Gaffner.
Now, this insurance policy here, as I understand it, it's in wide use. This is a frequently used and implemented policy, is that correct?
There are different versions of it depending on which risk pool, and typically they're reissued each year, and they vary, as most insurance policies do.
And if the other policies also include this coverage for incidental malpractice. Do you have any cases where that's ever been construed?
There was only one case in North Carolina that construed the definition of incidental malpractice. I actually briefed that case in the Pool case, which is the other one that's coming before you, but it wasn't an issue in this case.
But your issue is this isn't the insurance policy. This is essentially like a deck page.
It's a deck page.
It's pretty detailed, though, isn't it? I mean, I understand at the end it says coverage contained in the coverage document and referenced in this coverage certificate, et cetera. I mean, this is not the actual coverage.
Right. This court has said that these municipal pool documents are to be construed like we construe insurance.
Okay, but my point would be that this member coverage certificate is actually far more detailed than the typical deck page that you might get in another insurance policy in the world of private insurance. The deck page simply says, here's the limits or things like that, and what's included, what's not. This actually spells it out pretty well, doesn't it?
I don't agree exactly, Your Honor. This is an in-between. It's much more detailed than like an automobile deck page would be, but it's nowhere near as detailed as a commercial liability insurance.
Let me just
deck
ask
page maybe.
hypothetically, suppose they did put in the entire coverage, you got the whole policy there, and it sort of conforms to what the chief has pointed out here, that they're not providing insurance for anything that the MTCA gives immunity on. I mean, why would they write insurance for that? Well, I suppose they might, but let's assume that's the case. Would you, in that instance, have any argument that it has been waived when the policy specifically says we don't provide coverage for discretionary actions?
It would have to depend on whether or not their exclusions conflict with their definitions. It would also matter whether or not how they define incidental malpractice.
Yeah, I just want to say that incidental malpractice thing is kind of hovering out there. We don't have a whole lot of guidance on that because I don't know what it means either. But barring that, assuming that the actual coverage itself did clearly say we're not providing anything that the MTCA provides immunity for, including discretionary immunity, would you agree that that's the end of that story right there?
Well, I'll pretend that's the evidence in the case.
Oh, yeah, this is completely hypothetical because we don't have the policy.
And it was perfectly written that way.
Perfectly written.
Then I would have nothing to say.
Okay, all right, thank you.
Well, let me ask you about the amici brief that was filed by the state, which, as to the insurance question, I think what they're saying is because it's jurisdictional, one of the implications would be that you would have the burden of proof, and therefore you would lose on a summary judgment. What is your response to them saying this is jurisdictional and shouldn't be treated like an affirmative defense?
Well, you'd have to overrule the case that says that it's an affirmative defense that must be pled. Then you would have to.
We understand that.
You'd have to ignore Rule 8C, which.
Well, but do we have the power by rule to change that? In other words, if it's jurisdictional under the Tort Claims Act, do we have the power by rule to change that? AC is just a rule we've enacted, in other words.
There would be a procedure to do that, but the court could certainly amend its rules whatever way it wants to.
Well, and that's not my question. My question is, do we have the power by rule to change what is allocated to the jurisdiction by statute?
Probably.
Really? Interesting.
So one thing I would note, Your Honor, is in the reply brief, it was suggested that Rule 8C does not list immunity as a listed affirmative defense. To that I say read it again. It does. I was also challenged on the commentary where it said immunity was added as an affirmative defense and that the May 1st, 2020 commentary doesn't say that. I could understand missing that because the commentary is small print, but it's only 2 sentences long. Immunity was added in 2020 as an affirmative defense, showing that the trend is away from a jurisdictional argument and more towards having the burden on the proponents of the affirmative defense to prove it. And that's always how we've instructed juries, right? In the standard jury instructions, we tell them that the proponent of the affirmative defense defense has the burden of proof.
And assuming that's still the case, is it just a semantic exercise in futility to say affirmative defense, immunity, one or the other? Does it make a substantive difference here?
It would make a procedural difference, Judge, because if the AG had their way, every case at the beginning is going to have a Rule 12A jurisdictional hearing before we've even conducted discovery. And my experience has been...
Well, you would be entitled to jurisdictional immunity if we follow the same rules as the Federal Tort Claims Act, which is jurisdictional. Like the insurance issue, I think the AG said, well, you better go get a FOIA before you file suit. But you could also file your suit and then ask for jurisdictional discovery to find out about their insurance policy.
You could, and you try to, even before you file your notice of claim, you do a freedom of information, a freedom of access request, but what you get is a far cry from the hundreds of pages. You usually get a few dozen pages. So you know very little early on. Then you file your suit, and you're immediately on the defensive, and you have to ask permission of the court before responding to the jurisdictional dismissal request to do discovery. And we have that in an equivalent to that in Rule 56, where if you think you need to generate another affidavit or a deposition, you can ask for it.
So from a procedural point of view, it makes sense to put the burden on the defendant who is claiming immunity because of lack of insurance coverage, who is in possession of the insurance coverage documents, to have to put them forward.
Yeah, you know, they got the stuff, we don't. So it only seems fair that they should.
They got the stuff we don't.
So moving on to, I want to talk about Gaffner. The Superior Court declined to decide the issue of health care provider, health care facility, and the Superior Court was correct to do that because if you take a look at Gaffner, it's paragraph...
Well, do you want to address why we should even take an interlocutory appeal on the Maine Health Act security applicability? As opposed to immunity, where there's obviously a history of taking cases on immunity.
Yeah, I think they're done out of the gate. It's an interlocutory
That's
appeal.
what I thought your argument was going to be.
Not within any exception. And the court told them in Bean how to fall within that exception, which was to put the whole policy in front of the...
No, but I mean in terms of the applicability of the Maine Health Security Act to the jails, or whether they fall into provider, et cetera, which is their argument. There's no provider, there's no practitioner. Why is there anything that would make that appealable as an interlocutory appeal?
No, I see no exception for that. In fact, we've got a psychiatrist and a mental health professional who are also co-defendants in the federal action, who are waiting for their panel date, and our judicial economy would seem to want us to have the panel.
And the Superior Court indicated that that was essentially a fact question that needed to be dealt with, and was not going to rule on it. And is there, I guess I'm trying to figure out how that would be appealable, and whether, I think the defendants are saying that they have no other way to review the panel process.
I guess the short answer, I understand the question now. I think I misunderstood it before. The Superior Court addressed that at Appendix 2425, where it listed all the factual issues that were still unresolved. I think there were 15 of them, most of them dealing with the collaborative model. What role does the supervising licensed medical care provider have? What medical care function is the jail staff
So given
doing?
all those fact questions, my question is, putting that aside, the county defendants are suggesting that it should be, the denial of summary judgment on that basis should be immediately reviewable, because there is no other way to review the panel process. The panel process is not subject to appeal.
Well, that's true for everybody who appears before panel. And the way we deal with that on a due process perspective is when we go to court, the jury is told, There was a panel, it met, and if the panel's decision was unanimous, then it gets admissible on both issues. If
Or
it's
there
not,
could be a motion to eliminate to exclude any process or
Sure.
something like that.
But they get their factual shot in the panel to prove that they either are or are not a health care provider. And then when they get to the federal court, the federal court will apply Maine law on this pendent state claim. And the jury will be instructed that the panel findings are not binding. So they have a full opportunity to litigate
So
in two
bringing
separate
back
forms.
around, then, what you're suggesting is that it really doesn't meet the death knell exception.
Or any other exception, Your Honor.
And you're suggesting basically it's going to be the federal court that's going to have the whole enchilada.
And frankly, Justice Connors has sort of brought that up. I think the whole enchilada, this motion should have been in federal court when everything was completed. Thank you.
Thank you.
But of course, if we waited until we were in federal
Well,
court...
but let me back up on the death knell exception. With regard to the panel process, the panel doesn't enter a judgment, and it is clear that you can, I don't think there ever will be, but if there were ever a complaint in the Superior Court following the conclusion of the panel process, there can be motions in limine to keep those findings out, even assuming you lose at the panel process.
Here's why I think you ought to hear this appeal on the merits. If you don't, then claimants can bring claims against anybody under the Health Security Act, and anybody, a hospital janitor, a school security guard, can have to spend...
But isn't that how it's structured?
Well, that's why there's an exception to the interlocutory judgment rule, so that you can say, no, wait a minute, this is not the intent of this statute, it's being misused, and we are spending hundreds and hundreds of hours of people's time, thousands and thousands of dollars of people's money, litigating cases when they're not involved in the healthcare industry, they're not healthcare providers, and I think that's the reason that you ought to entertain this on the
Thank you,
merits.
counsel.
Thank you, Your Honors.
Thank you for your argument here this morning, counsel. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, I think we're in recess for the morning.